I'm Nick Grief, a Professor of Law at the University of Kent. In this lecture, I will offer some reflections on the European Court of Justice's judgment in the Van Genten-Loos case, VGL, delivered in 1963, arguably the court's most important judgment ever. So important, in fact, that in May 2013, the court organised a colloquium to commemorate the judgment's 50th anniversary, the proceedings of which are on the court's website. In the light of Brexit, this may seem an odd topic to choose, but I've been studying European Community, now Union law, alongside international law for almost as long as the United Kingdom has been a member state. First as a student here at Kent in the mid-1970s, and now as a professor in Kent Law School. As part of the acquis when the UK joined the communities in 1973, VGL is a case that continues to fascinate me and to make me think. It was in Van Genten-Loos that the European Court of Justice articulated the doctrine of direct effect, according to which European Union law can create rights for individuals that national courts must protect. And the court made it clear that this is a hallmark of the new legal order of international law created by the treaties. Over 50 years on, the judgment continues to provoke strong reactions, dividing those who welcome it as a legitimate exercise of teleological or purposive interpretation from those who denounce it as a classic example of politically driven judicial activism, of the court trespassing outside its province, as Professor Hampson once put it. As my contribution to this debate, I'm going to suggest that the VGL judgment was a logical and even foreseeable development that had its roots in a combination of international law and the European Court's previous case law concerning the Treaty of Rome. First, though, the facts. In September 1960, Van Genten-Loos, a Dutch company, imported a product from West Germany into the Netherlands. When the Dutch authorities demanded 8% import duty, the company refused to pay, objecting that when the Treaty of Rome had come into force on the 1st of January 1958, the duty payable had been just 3%. The company argued that since Article 12 of the treaty required member states to refrain from increasing duties which they already applied in their trade with each other, it could not be required to pay the additional 5% duty. The company's objection was dismissed, so it appealed to a duties tribunal in Amsterdam. That tribunal suspended the proceedings and referred the question about Article 12 to the European Court of Justice for a preliminary ruling. More specifically, the tribunal asked whether, besides imposing obligations on member states, Article 12 created rights for individuals which national courts had to protect. The European Court of Justice held that it did, noting that the functioning of the common market was of direct concern to all interested parties, that the treaty's preamble referred to peoples, that nationals cooperated in the functioning of the community through certain institutions, and that the preliminary ruling procedure itself presupposed that community law could be invoked by individuals before national courts. The court concluded that the treaty had not simply created mutual obligations between the member states, but had created a new legal order of international law, the subjects of which comprise not only the member states, but also their nationals. Community law, declared the court, not only imposes obligations on individuals, but is also intended to confer upon them rights which become part of their legal heritage. The European Court went on to say that since Article 12 imposed a clear and unconditional obligation upon the member states, the obligation to refrain from increasing customs duties, the corresponding right could be invoked by individuals like VGL in national courts and tribunals. In other words, Article 12 had direct effect. Now, the idea that a treaty might be intended to confer rights directly on individuals was not new. It had been recognised by the Permanent Court of International Justice, the International Court's predecessor, in the Danzig case in 1928, 35 years earlier. After admitting that according to a well-established principle of international law, an international agreement could not, as such, create direct rights and obligations for individuals, the Permanent Court departed from that traditional view and emphasised that it all depended upon the intention of the parties, a test that the court said was satisfied by the wording and tenor of the agreement in question. In an appraisal of the Danzig case, in his book The Development of International Law by the International Court, published in 1958, Sir Hersch Lauterpacht, who was then the British judge of the International Court of Justice, commented, "The acquisition of treaty rights directly by individuals was made a function of the intention of the parties. The court denied the exclusiveness of states as beneficiaries of international rights." As Professor André Nolkamper of the University of Amsterdam has observed, the European Court's proclamation in VGL that a treaty created individual rights which national courts must protect took the old Danzig doctrine into territories unknown to international law, and even seemed to take international law away from the very states that had created it. But the European Court may have been influenced by other international law precedent besides Danzig. In his book, Lauterpacht went on to note that in its 1950 advisory opinion on the international status of Southwest Africa, the International Court held that Article 80 of the UN Charter, in the chapter of the Charter on the International Trusteeship System, maintained the rights, the international rights, not only of states, but of peoples. These rights arising out of the League of Nations mandates. Could it be, I wonder, that the ECJ's reliance in VGL on the Treaty of Rome's references to peoples as a basis for recognising individual rights was prompted by familiarity with that advisory opinion? Be that as it may, it's often said that the ruling in Van Genten Loos came out of the blue. We know that 3 of the 7 judges, including the juge rapporteur, the reporting judge, rejected the idea that Article 12 could have direct effect. For his part too, the Advocate General Roma, opined that large parts of the treaty, including Article 12, contained only obligations of member states, not rules having direct internal effect, noting that the treaty had its own self-contained regime for dealing with breaches by member states. Similarly, the 3 governments that submitted written observations from Belgium, the Federal Republic of Germany, and the Netherlands, they all saw in Article 12 only an obligation on the part of the member states. Besides Van Genten Loos itself, only the Commission argued that Article 12 had direct effect, such that national courts and other authorities were required to apply it directly. In that context, even in the light of international law, the ECJ's decision may seem surprising. But let us also take into account the pre-VGL European Court case law from the European Court reports for 1962. Is there anything there that helps to explain the VGL judgment? I think there is, and against that background, I want to suggest that the court's recognition of direct effect in the Van Genten Loos judgment was a logical and necessary development. In those 1962 law reports, we find the European Court fully respecting the treaty's terms where they imposed conditions or limits, but being prepared to exploit the treaty's silence. We find the court emphasising the importance of ensuring that the treaty's provisions are effective and that its intentions are fulfilled. And we find it referring to the letter and spirit of the treaty. Now, those judgments include two joined cases in which the Commission brought infraction proceedings against Luxembourg and Belgium for failing to fulfil their treaty obligations. The European Court emphasised that the fundamental principle of the free movement of goods would be destroyed, réduit à néant, by the general application of protectionist practices like those at issue, which the court said would lead to an absurd situation, the exact opposite of that intended by the treaty. Strong language indeed. It seems to me that in those early years of the communities, the court was very worried that unless the enforcement of those fundamental obligations was ensured, national protectionism would destroy the European Economic Community before it had really begun. The situation demanded vigilance, not only by the Commission, but by individuals. But the European Court needed the opportunity, the right case, and the right question from a national court, and perhaps even a nudge from the Commission and Van Genten-Loos's lawyers. It's no coincidence, perhaps, that Judge Lecour, one of the two authors of the Van Genten-Loos judgment, had been the juge rapporteur in the case of the Commission against Luxembourg and Belgium. The other prime mover was Judge Trabucci, whose referendaire, or legal secretary, at the time of VGL was Paolo Gori. Now, in his paper at the 50th anniversary colloquium, Professor Gori referred to a note prepared by Judge Trabucci for the court's deliberations in VGL, opposing the position taken by the juge rapporteur. And Professor Gori gave this robust and convincing defence of the European Court of Justice's judgment. I quote, "Are constitutional judges who take into account the social and economic consequences of their decisions acting politically? If the effects of the court's decisions can, and in my view must be taken into account by the judges in their discretion to avoid producing major damage to society, we must also admit that to make choices that the letter and spirit of the law allow, good judges, and particularly a constitutional court, must consider the benefits that their decisions could provide for society." Seen in this light, direct effect, in my view, was a legitimate and understandable and even foreseeable development. Did the framers of the EEC Treaty intend it? Well, direct effect wasn't mentioned in the treaty, but then it still isn't, even though it's now an established part of the EU's constitution. So I don't think that can be conclusive. What we can say is that in introducing direct effect into the community legal order, the European Court did not contradict the treaty, though it certainly added spirit to the text. It took advantage of the fact that whether or not the treaty hinted at direct effect, it certainly didn't preclude it. The court sought to make the treaty effective, as the treaty's founders surely intended. And in order to do that, consciously or otherwise, the court adapted what the World Court had said in Danzig and Southwest Africa. No doubt Judge Lecour and perhaps some of his fellow judges on the VGL court knew those international cases well. It's worth noting that before his appointment to the ECJ, Monsieur Lecour was a minister in the government of French Prime Minister Michel Debré, with responsibility for cooperation with France's ex-colonies. I'm sure he would have been familiar with UN decolonisation law. It's fashionable to criticise the European Court of Justice for its activism. Sometimes that criticism is deserved. Take the Sturgeon case, for example, where the court effectively rewrote an EU regulation so that airline passengers would be entitled to compensation for long delays and not just for cancelled flights or denial of boarding, contradicting the specific terms of the legislation. For that, I think the court fully deserved the Advocate General's rebuke that it was usurping the prerogative of the legislature In future, it would do well to show greater deference to union texts. By that yardstick, however, VGL was not the judgment of a court trespassing outside its province, as Professor Hampson once argued. It was a logical masterstroke rooted in the treaty and in international law, and not inconsistent with either. It meant closer scrutiny of the member states' actions and more effective enforcement of the obligations they'd undertaken, thus helping to ensure that the treaty's objectives and its founders' intentions would be achieved. And above all, in keeping with the treaty's references to the peoples of Europe, and in conjunction with the doctrine of supremacy emphasised in the Costa case the following year, which was similarly grounded in international law. Van Genten Loos and the developments it subsequently inspired has empowered individuals, people like you and me. There's no better example than Helen Marshall, the NHS dietitian, who in the 1980s was forced to retire 5 years earlier than a man doing the same job, simply because she was a woman. She was able to bring and win her case and full compensation for the sex discrimination she'd suffered because of the doctrine of direct effect articulated by the European Court of Justice in that remarkable and yet in some ways unremarkable VGL judgment. Thank you very much for listening.